Hello, everybody. I'm going to wait until I see the room continue to fill as you all go from waiting in the webinar mode to being here live with us. So thanks for joining. Thanks to all of you who read along with us, Privacy at the Margins. We're super excited that we were able to catch Professor Scott Skinner-Thompson. I think the semester's over, right? Are we? Okay, so I at least don't feel terrible about, although you're probably grading right now, so it probably is actually a pretty busy time. So really appreciate you taking time out to be with us, and frankly for this great contribution. And thanks to all of you who've been reading at home and keeping up with us. We welcome your thoughts. If there are other books on your shelf that you ought to be reading, and having a bunch of us all doing it together and a chance to chat about it makes it a little bit more appealing. We are eager. So for those who are joining for the first time, we try to make this as informal as possible. This was once an in-person club where, someone showed up with wine and snacks, and we had 15 or 20 of us in the greater DC area that would host it in person. And then at some point we moved it into the FPF offices and did it over lunch, and flipped on Zoom so that remote people or the author could zoom in. And we're glad that we will keep it going. Let me just quickly tell you who I have in the room, but those of you who are not in the room or are not second-class citizens here, please raise a hand, chat. We'll light you up into the room if you want to ask a question directly, or feel free to put it in the chat and one of us will call it out, or raise your hand and we will we'll make things happen. So quick introductions. First of all, Marcus, one of our fellows with us who's been coordinating the book club and juggles a lot of other policy work at FPF. So Marcus, thank you for helping make this happen. Some of you probably already know from her days at FPF, Caitlin Ringrose. Caitlin has moved on to a role at Google, but is still part of the FPF family. She's a data governance and security analyst over there. Divya Ramji, Divya, I pronounced it right? I think I did, yes. Divya is a PhD candidate and an adjunct professor at AU, American University, and a senior fellow at the Center for Security, Innovation, and New Technology. And Kobin Zweifel-Keegan, Deputy Director of Privacy Initiatives at the Better Business Bureau National Programs. So they're all here to chat along with us and ask Professor Skinner-Thompson some questions and perhaps share their review. But without further ado, let me invite our author who is with us today. I'll just quickly tell you that although I'd heard the book and I bought it because it sounded interesting, it was sitting on my shelf and not yet read. And I noticed that a number of leading academics were convening virtually for a program that was hosted at the Colorado Law School, University of Boulder, all around this book, because I think of the real moment that it touches and the themes and the analysis. And I heard great things about the program, and I realized we had to read it, and was not at all disappointed. So let me turn over to you. What's been the reception? What was the driver? Was this in you for a long time? Obviously, it builds on some of your broader work on issues affecting marginalized communities. Love to get your thoughts and and I know there's always some people that actually didn't read. So any general you teach, that. So
right, no, definitely.
a picture of the scope.
Usually assume there hasn't been reading. So no, thank you, Jules, and thank you so much to everyone.
And I didn't introduce the most important person in the room, at least to me. Nathan Lewin, Supreme Court litigator, longtime constitutional law expert, professor at Harvard Law, at Columbia Law, at lots of other law schools over his year. Wonderful father-in-law, among other things, and with a particular tie to one of the Supreme Court cases, and was generous enough to let me grab some on-the-ground insights from actually representing, and we'll come to him afterwards. Thanks.
Yeah, no, thank you, Jules, and thanks to all of you for taking the time to engage with the book. by way of introduction and an answer to Jules' question, I guess my sort of initial gateway into thinking about privacy for marginalized groups was about a decade ago when I was in private practice and partnered with the ACLU LGBT and HIV project to research states with fertile state constitutional informational privacy law to see if there was a good state to bring a challenge to restrictive gender identification document laws and perhaps surprising to some, Alaska has, the West tends to have much more detailed state constitutions, and there's a libertarian ethos in some of those constitutions. And Alaska has a really great state constitutional privacy law. They also, unfortunately, had a restrictive law when it came to changing the gender marker on your driver's license. And so we recommended that they bring along lawsuit there, and they did successfully getting change based on an informational privacy theory. And so that really got me thinking about the role of privacy for different marginalized groups. And it turns out that marginalized groups have actually been thinking about privacy for a long time because privacy has served as a key, or lack of privacy has served as a key way to further group subjugation. And this holds true for feudal societies, and it's just as true, if not more so, today. And I think that the project, which evolved, really started to center what the privacy law community could generally learn from the communities that are most vulnerable to privacy violations. And I think that what became clear to me is across many different vulnerable groups, whether it's people of color, immigrants, queer groups, people of limited economic means, is that all of these groups were engaged in kinds of surveillance resistance, right? And they were using it as a tool of not just an instrumental means of keeping certain information private, but actually using it as an outward-facing communicative tool of anti-subordination and resistance. And indeed, the government gets that, and they often target the groups for additional surveillance based on their resistance. But I think that if we focus more on privacy's outward-facing anti-subordination role, then there could be a couple benefits, both in terms of doctrine and in terms of the way we think about privacy. In terms of doctrine, I think there's a strong First Amendment argument to be made, which at this moment is critical because the First Amendment is often viewed as enemy number one when it comes to privacy regulations, as folks at FPF know well. And so I think that might help not just in terms of constitutional protections vis-a-vis the government, but also might help governments that want to enact privacy regulations as to corporations more successfully defend those privacy regulations. So I'll leave it there, but those are how I got interested in the topic and how it sort of evolves, and how I think it might have some use as we all work together to create more privacy.
Yeah, I wonder whether you could say more. I mean, but you point out quite well that privacy in public, you still have the ACLU, often taking, a strong position that despite concerns about privacy restrictions that would limit, media, that would limit speech, that would limit what happens in public, that or access to public information. And that's really been a point of contention. So wonder, say more, if you could, about how you see theorizing informational privacy in this way, providing maybe a counterbalancing that would make an issue of speech versus speech. Is that? Yeah,
no, and it's an important point, and I think that ACLU's position on this has evolved, right? But so, and just to concretize some of the problems, I think the Clearview litigation is a good example, right? So Clearview AI says that any attempts to regulate their effort to scrape social media profiles and train their facial recognition software is a violation that's protected under the First Amendment, because that information is exposed to the public, and therefore, as consistent with jurisprudence recognizing a right to information gather, and as Jules noted, a lot of those early cases dealt with media rights, and I think that's an important distinction which we can come back to, but that means it's free game, they can't be regulated. And I think that, undoubtedly, there is a strong constitutional and democratic theory basis for protecting access to information that has been publicly exposed. But I think that interest is particularly acute when we're dealing with government information or information pertaining to matters of public concern, but that undergirding principle does not apply equally to all information. Okay, and I think that to say that in today's social context, that just because your picture is on a social media site, that it's a matter of public concern is a great stretch. And a lot of my colleagues have critiqued and really emphasized this point, that these images are not a public concern. I think that's an important point, but I think even potentially more or buttressing that point is that people who care about their privacy, okay, whether it be in any way, are instrumentally trying to keep information private for a future purpose, maybe a future First Amendment purpose, such as developing ideas for future expression, as underscored by Neil Richards in his book Intellectual Privacy. But I think that they also are expressing something outwardly to society about why they care about privacy and why it's important to that. And in this social context of assumed privacy surrender, when people start taking more and more efforts to resist surveillance, I think that is of expressive significance and can be used to justify and defend privacy regulations such as those that are being used to come down on Clearview.
And you make a point that I think is perhaps, for those of us who are actually, in the weeds on some of the state legislative efforts. I see in our audience folks like Joe Jerome, who's been testifying at a lot of the state legislative hearings, and others. You make the point that although there's a lot of conceptualizing of privacy as about individual autonomy and broad thinking like that there might be a real strategy around advancing theories that do focus on the way marginalized classes might be at particular risk or harm. And you're sort of almost defensive about that because, well, then maybe that means giving up, broader rights. And I think, but you sort of walk through how, that doesn't need to be the case. But I wonder, was that part of the dialogue sort of at Boulder? Has that been sort of a criticism, and how do you sort of respond that if we're only going to protect vulnerable classes, are we then giving up a broad theory of privacy for all?
I think it's an important question. I think it has been a point of pushback that I've gotten when discussing the book in certain contexts, and make no mistake, I think that privacy matters to everyone and should be available to everyone. But my point in sort of emphasizing the unique and disproportionate harms to marginalized groups isn't to say it doesn't matter to these other groups, but instead to say we have been ignoring how it matters in particular significance to marginalized groups, and we need to put that on a pedestal, prioritize that, and that has benefits not only to members of the marginalized groups, but I believe that it will have benefits flowing to everyone because it will lead to, I think, more robust privacy protections, particularly at this social moment. And there's good literature talking about how the Supreme Court, in many different contexts, okay, you know, take gay rights litigation, for example, they are most comfortable robustly protecting individual constitutional rights when there's sort of a confluence of constitutional issues at play. And so I'm saying if we underscore equality, privacy, expression, that's going to lead to better judicial uptake. And I think we saw that in the gay marriage cases, right? We have due process, equality, federalism, right? All coming together. And that's why Kennedy was critiqued in many of those opinions. He's like, what is this case is about? And I think that, you know, is an important critique, but I think it also gestures to a vein of authority where the court is most comfortable robustly protecting rights when there's a confluence of fundamental rights at issue.
So speaking of the Supreme Court, our monthly call for FPF stakeholders this month focuses on the fact that the Supreme Court has three really interesting privacy cases that are likely to be of interest. I guess one, we already had a decision, the FTC authority decision, and we've got two more. So it was particularly timely to have your sort of survey, your dive into how the court has handled informational privacy when it's come up. And so maybe on that note, let me ask you just to tell us how you brought in the Nixon versus administrative general services, and then we'll turn to Mr. Lewin to give us a little bit of the on the ground. You know, what was privacy front of mind as a key issue when the lawyers argued this case back in these days after Nixon had left office. So.
Yeah, and I think it's a great question. I'm really interested to hear from Nathan. You know, the evolution of privacy law, as many people may be familiar, the Fourth Amendment, particularly in the 60s, was really where it was at. And I think that there's good reason for that, but I think it did, in some ways, double down on a sort of narrow vision of what privacy is, underscoring the role of intrusions. And I think that you see that in the way that early informational privacy cases like Whalen and Nixon were litigated. And of course, when Nathan filed the briefs in Nixon, probably didn't even have the benefit of Whalen yet to underscore. I think that Nixon was argued 2 months after Whalen was decided. And so in those cases, where in my view, the real privacy threat was about disclosure of certain intimate information, the cases were often briefed and conceptualized by the Supreme Court as they're like, we can't analogize this to the Fourth Amendment. They had a really hard time. You can see the court in the Nixon opinion struggling, trying to fit what they saw as a round hole in square peg. And so part of, and I think that struggle endures, right? I think that we still struggle with this sort of intrusion myopia, and in other contexts, this autonomy myopia driven by the decisional privacy rights coming out around the same time. And so part of the project is to think about informational privacy in a more categorical way, and think about the harms in a less abstract way, right? Because the Fourth Amendment cases all say, oh, it's just the entering that is the harm, regardless of what they find. And I'm not sure that's the same when it comes to informational privacy. I think that what the information is that's disclosed does matter, and we shouldn't treat all privacy violations when it comes to disclosure as the same. And so that's what I'm trying to underscore in that context.
Well, Professor Lewin, when I called you last night, when I was reading this part of the book, you may not have had time to go back to your files, and this was way back in the Nixon years. give us some flavor of what was actually happening. You can unmute while I do this. What was happening back in those days? Professor Lewin was a Supreme Court clerk for Justice Harlan, founder of the Miller, Cassidy, LaRocca, and Lewin firm, out of business now, but known as a boutique that drew Supreme Court clerks. Folks like Jamie Gorelick and Seth Waxman and other luminaries of today's bar were proteges and learned how to write a brief at Miller Cassidy, working for Mr. Lewin. In addition to working in the Solicitor General's office and the Kennedy Justice Administration, he and the firm did some work for Nixon in this battle over his papers and his archives. What was going on, and how much was privacy kind of part of the debate back when you drew up these briefs and advanced the case?
Well, let me say first that I'm both flattered and pleased that my son-in-law, Jules, has invited me to this group and had me focus attention on this. Of course, in his belated introduction of me, he did what he sort of briefly did again now in a statement. I was a member of a firm that was really quite extraordinary. The latest appointment to the Supreme Court of the United States, Amy Barrett, was an associate in our firm. And in addition to Jamie Gorelick, Seth Waxman, David Cohn, various people who held very high positions in government, it was an extraordinary firm. It was the firm of Miller, Cassidy, LaRocca, and Lewin. But in short, it was called Miller Cassidy. So my name was dropped out. So when Jules introduced me right at the beginning of this program, he introduced me as his father-in-law, which is appropriate. I love Jules. We're very proud of what he's done, but he forgot to mention my name. And again, that's something that I've had to suffer through my professional career with Miller Cassidy, LaRocca, and Lewin. Now, the Nixon case was argued just a couple of months after Whalen was decided. It was argued by Miller and me, both the first and last names in the firm. We shared the argument, and it was Miller who really dealt with the privacy issues. I was assigned to, and during the time that I had during the argument, I dealt with the questions of confidentiality, of government communications, essentially tried to analogize what the papers would show with regard to Nixon and people around him to what Supreme Court law clerks would communicate with Supreme Court justices, and tried to make that argument. And then, of course, I also made the argument on which I personally thought we should win, except that it was, quite frankly, at a time when it was impossible to win a case representing Richard Nixon. But that statute was, without a doubt, a bill of attainder. And the court dealt with that in its opinion, in addition to other questions. But those were the two areas that I covered. Miller, in the argument, right at the very beginning, noted right at the very beginning that what was taken included matters highly personal, such as conversations with his wife, conversations with his daughter immediately prior to her marriage, conversations with his counsel, with his physician, and with his clergyman. But where I think there was an essential difference in terms of the Nixon case and the cases that you're talking about and Whalen, is that the issue in the Nixon case was the screening process. Nobody, but nobody, claimed that it would be permissible to take Nixon's personal papers and make them subject to some, governmental or whatever would be a governmental body of information, which is what Whalen involved. As I understood Whalen, and as I do now too, it is a question of whether if you take certain kinds of data and you store it, and that includes some personal data, what are the constitutional ramifications? That was not an issue in Nixon. The adversaries we had, which included the Solicitor General, Wade McCree very clearly in the argument said that on its face, if the law instructed or authorized the impoundment of purely private papers, I would not be here to defend it. In other words, there was no question in Nixon that as to Nixon's private papers and the private communications, they had no business being stored by the government. That was not, everybody agreed that that was not to be, that's not proper and would not be, we argued it. We didn't cite Whalen in our brief, which I really wrote most of that brief, including the privacy part, but did not cite the Whalen case, which of course was decided just a couple of months before we argued the case. But that wasn't the issue in Nixon. The issue in Nixon was, in terms of privacy, could a screening, some discreet, quiet screener go through this and give Nixon back his private papers? And Miller acknowledged during the argument, and I look back at the argument now after Jules invited me to participate in this, Miller acknowledged that when the case was brought, when the lawsuit was initially enacted, immediately after the statute was enacted, everything was frozen. And he did not ask, nor did anybody ask prior to the argument. Miller acknowledged it at the very end of the argument that nobody asked to have the private papers returned yet. That was still all up in the air until the time of the argument. So the only issue with the argument is, can papers be taken and then subject to some screening process by some, very confidential group or person who would look through the papers and then give those private papers back to Richard Nixon? That was the issue. And that's the issue that the court dealt with in its opinion. The portion of the opinion which deals with privacy, and if you look at that, it's Roman 5 of the opinion. It's a long opinion, of course. And it says that it's a reasonable response to say, we take all the president's papers, because only very, very small number of those 8 million documents, maybe 200,000, are really private papers. And we say that they can be screened by somebody so that the papers can be given back to Richard Nixon. And the court, in its opinion, because it was very fresh in the court's mind, does cite and discuss Whalen and distinguish it. But we didn't present a Whalen argument to the Supreme Court.
So if I may, do you think Nixon, the decision has long been characterized as one of 3 Supreme Court cases dealing with constitutional informational privacy? And if I'm understanding you correctly, you might almost say that you think that description and inclusion with Whalen and then NASA versus Nelson is misplaced?
I think it is. I mean, in terms of the reality at the times, we did not think of it as a case that involved those issues. It was, is it appropriate to take a whole slew of papers on which the government has an interest and then say, okay, we've taken it, but we'll have somebody look through it and give you back the papers that you're entitled to. That's what was assumed at the time of the Nixon argument.
But did anyone raise, or it seems like today, obviously, when these sorts of issues come up, somebody's got a computer program and it'll pull out everything that has certain keywords or this or that. Here, clearly, some human being is going to be reading Nixon, even if a confidential master with 12 clerks in a room, someone's going to be reading his communications with his clergy person, with his spouse. Who knows what ugly things might be said in that kind of communication. No sense that even if not made public, would be an intrusion.
Well, that was our argument. Our argument was, look, you can't take all those papers, which have what is indisputably very private communications that the government has no interest in. What did Richard Nixon say to his daughter on the evening before she got married? Now, 1 minute now, nobody could possibly have an interest in that. Maybe some, biographer who would have access to other private Nixon things, but no government agency should have access to that. And our argument was the whole thing, the whole statute is unconstitutional because you can't really separate that out without violating what is the prohibitions against a general search warrant, in which you take everybody's papers without specifying what it is you're looking for, and then after you look through it, you return what you think you didn't want. That's unconstitutional. That was Stanford in Texas, and that's what we relied on.
Interesting. Well, let me turn to others here in the room for the issue at hand or reactions to the book in general. What struck you? What would you want to ask? Thoughts welcome. Caitlin, Coben, Marcus, Divya, you love the book? You hated the book?
I wouldn't say if I hated it, but I definitely did not hate it, Scott. I loved it. Thanks for having me. Coben, love your pillow in the background. It's wonderful. And Mr. Lewin, this is a fantastic opportunity to meet you. I was a student of Amy Coney Barrett, so a very small world here. I think the arguments you're saying in Nixon are kind of echoed today when it comes to encrypted communications and decrypting communications or running AI systems that are basically independent overseers in those systems to detect certain materials or certain information. So I think what goes around comes around, and now it's just a new feature of technology. And I think we're going to see those same questions crop up here over whether you can have just one person or one system monitoring information to pick out what may or may not be illegal content. So I find that super interesting. But I wanted to just, say on your point, Scott, about performative privacy. During the pandemic, I've been wearing my mask all the time, and I had almost celebrated 1 year of not being like catcalled or hit on the street or, in the store. I was super excited. I was ready to celebrate that 1 year. And then, just the other day, I was walking down the sidewalk with my mask pulled down and somebody was catcalling me. And at the time I still am very offended. But what I think it made me realize is just how valuable this past year has been, and the fact that I've been able to mask up and go to the grocery store in pajamas and all of that. So if you could chat just a little bit more about the importance of performing privacy and expressive privacy as a form of resistance. I think that's important. We often talk about privacy preserving, and I think here we're talking about something that's a little bit more resistance oriented.
Well, thanks so much, Caitlin, and I'm so sorry about the cat calling. I think there was an interesting article that was written in The Guardian this past week about how some people have really come around to masks since the pandemic, for some of the reasons you're mentioning, that it provides a degree of comfort in not having to be on call all the time, and protection. And I think that I think that's of significance. Obviously, when I talk about privacy resistance, and some of these things are really quotidian, like just lowering your voice on the subway or something, or shielding your book or your phone, and I think many people do them for don't think about it as a form of resistance, and but some do. In my view, that doesn't really detract from the fact that it is understood as resistance by the surveillors, and that they target people for additional surveillance. And I'd be interested in people's obviously this is purely anecdotal, not social science, but whether or not during the time of wearing the mask, and when there was a choice about whether to wear the mask, whether people felt ever like they shouldn't wear the mask because it was creating suspicion around them, or not. I think there's going to be a lot of social science about that topic and our privacy choices now that masks mean many different thing. And the last thing I guess I'll say about performative privacy is I do think that in terms of the doctrine, and getting a little bit back to some of Jules' questions, is that the First Amendment is, in my view, extremely pliable and attentive to social context, and we've seen that in a whole host of Supreme Court cases. And what I think is going to be interesting is, as social norms around privacy continue to evolve, whether or not the idea that privacy is performative and expressive actually loses salience over time, if as I hope, more people begin to care about their privacy.
Opa, a quick thought. My father is called Opa, or the Dutch for grandfather in our family. Scott in the book talks a bit about wearing a hijab and so forth as one of these examples of performative privacy. You've argued a range of cases in courts up and down around wearing a yarmulke and so forth, but also things that were more in line with religious privacy, people covering hair, wearing turbans, wearing other modesty type issues. Have those always been solely based on religious freedom? Has there ever been a reason to try to argue that there's a First Amendment, a speech reason that when somebody is wearing one of these modesty things from a religious argument, that there's therefore a speech component to it as well, or a private informational privacy type component?
Well, the answer to that question, a clue to the answer to that question, is something that you and I, and maybe one other person who I see here, have in common, which is wearing beards. That there has been an argument made unsuccessfully that the wearing of a beard should be permitted as First Amendment expression. The courts have rejected that. The wearing of a beard for religious reasons has been upheld and sustained. So, I mean, in the cases that have involved clothing or wearing a Sikh, a little dagger or something, it has not been viewed as sort of speech, but as an expression of religious freedom. I have represented people in cases of wearing a yarmulke, and in cases of even I filed an amicus brief in support of the young lady who, for Muslim reasons, for reasons of the Muslim faith, was also dressed in a hijab at Abercrombie and Fitch. So I think those are religion cases, really, not speech cases.
Thoughts from others here in the room? Marcus, what was your reaction to the book?
I thought it was great. And the question I had is, you mentioned in your intro that we're in a moment now. Do you see that translating at all at the federal level to some kind of privacy protections for marginalized communities?
In terms of legislation,
Correct.
I think that it would be, I mean, and all of you focus on legislation more than I do, so I'd be interested in your thoughts. But I do think that there is something to say for it's not quite interest convergence in the way that Derek Bell meant it, but trying to find the ways in which whatever the right that you're advocating for can where there's synergies with other things people care about. And I think that when that's occurred, we've seen greater success. I think that that's true in some of the history of our civil rights federal statutes. Not all. Sometimes more groups get protected or added in order to sabotage the legislation, right? Like sex was added to Title VII, not to broaden it, but as a poison pill. But I do think that to the extent that privacy legislation can be linked to protection for marginalized groups, which more and more people in America are concerned about both of those issues, then it could strengthen the chances for that legislation. Now, obviously, privileged people care about their privacy too, but they don't need to rely on the law to protect themselves. They have the means most of the time to build the privacy barriers, or if there is a privacy violation, to get recovery on the back end, with Hulk Hogan sort of being the archetypal example, but there being other examples of celebrities doing really well where other people, including related to the previous question, Muslim women have not done as well.
I guess the way we see it popping up at the state level is obviously we've got some states, Virginia, for instance, where special category or sensitive data gets called out for consent as opposed to everything else that you can collect, and you maybe got to give an opt-out of sale. And then on the automated decision making sort of AI types areas, right, we see obligations to let people object or give them explanations, or some rights if it impacts civil rights in some manner. And I think a lot of the debates in the state level have been all around, do you need a private right of action? Do you not? And what hasn't been the focus, but I think is going to be a much bigger issue, is actually what does it mean to extend civil rights the way many are suggesting ought to be done. There are states that don't have civil rights protections for internet as public accommodation. Civil rights groups would like to see privacy law extend that. But I think that's not been, I think, the big source of sort of debate back and forth in the states, and it frankly is probably more important than how many people get to sue, although obviously that's a relevant factor. Coben.
Yeah, I was just gonna. That's exactly. It's a great point for me to build off of kind of my thoughts. I think especially things that have stuck with me in reading this book. I think as similar to many people probably in the book club on the call, I'm focused day to day on more data privacy issues, more privacy governance type issues, and so I'm looking and reviewing this despite my interest in or on top of my interest in the social science and everything, and in the constitutional issues, in trying to find lessons for how we do privacy governance better. That anti-subordination focus of this book is what really has stuck with me. This idea that there is that we can't be blind, that in order to bring equal rights protections into privacy, whether in a constitutional or a tort focus, or even maybe in the data privacy focus, we can't necessarily be blind to the special interests of marginalized communities, of the data subjects themselves. We can't necessarily treat them all the same. So that's an interesting, like, additional element when you're thinking about how to write privacy law or apply different privacy standards to how we're collecting and using data, because it's not necessarily just about the sensitivity of the data itself, like the intrinsic sensitive type of data, or the purpose for collection, but also who it's about and the broader context. I think Scott builds a lot off of Helen Nissenbaum's work about of context, the broader context of the social interaction, where the how the data is going to be, like the social interaction of the I don't know, for example, like a platform, as if we're talking about a online platform, the social context matters there, and that's particularly true for marginalized communities, where that even a small disclosure to a small group of people could have huge impacts. So I think that's what stuck with me primarily in doing that, and especially in re-reviewing it again before this call, just trying to look for those nuggets, both thinking about, I think it actually intensifies the call for to actually protect certain categories of data more, and particularly intimate data and political related data. But I think, I guess one other thing, if I could, that I found, I think this comes more from the Silicon Flatirons event you were talking about, Jules, that was built in some ways around this book. There was a professor, Karen Levy, there, and she was talking about how data collection is intrinsically related to power. And that was one of the really compelling discussions for me in thinking about how all of this relates to choices about how we design technical systems and privacy governance, because she gave examples of, like, Nest cams, right? That we treat the person who runs the Nest app, the head of household, gets to make decisions that are privacy decisions that could be detrimental to people that don't have as much power in that household. That for me kind of brought it down to this really granular level that goes beyond even broad categories of protected classes.
No, I think it's a great point, and I think that it underscores, in some ways, to the extent the book has a value, like the value in or contribution in terms of focusing on marginalized groups, but it is also under inclusive, right? That is, in the, you could make stereotyped assumptions about who has this power in the example you just gave, the Nest example, but those aren't uniformly going to be true, right? And so, and they won't be true along, won't always be true along demographic groups, and I think that's a critical point. My view of this is that in some ways it's a bit of triage, right? And I think that that starting with protections, even if they are under inclusive for kinds of information that tend to be associated with more marginalized groups, like intimate information, with it tends to be weaponized against women and sexual minorities, for example. If we start with that kind of information, is it going to solve everything? No, but it'll get us partway there. And here, you know, the approach to anti-subordination draws not just from, you know, critical disciplines like critical race theory and queer studies, but also really just public health, like as a matter of harm reduction. Okay, there's real value in putting certain groups, foregrounding the importance of their information when we're dealing with either constitutional law, tort law, or privacy regulation. And again, part of that is, you know, stopping harm that's occurring today, concrete harm that's occurring today, but also the laws, as you know, and as in Ari Waldman's work, including his recent work, focuses on more the performative aspect of privacy legislation itself and the positive influence of law. That each law that you folks help get enacted isn't just about the constituents it protects, but it influences norms and behaviors more broadly. And so I think that to the extent that the anti-subordination focus helps get the foot in the door, so to speak, for privacy values more broadly, then it will continue to have flow-on effects.
Divya, let me bring you in. You've been involved with the Cyber Civil Rights Initiative, which deals with helping and advancing policies to deal with victims of unwanted sharing of intimate photos and the like. What was your what resonated with you?
Yeah, so thanks for having me. I'll keep my comment brief because I know there are attendees who have questions, but I think, you know, as a social science researcher, I really appreciated the legal parts of this, but I appreciated the fact that you're bringing these discussions about classism when it comes to privacy rights and how we define who deserves to have that right to privacy. You know, you had this excerpt about NCP, which is non-consensual porn, and the fact that if a woman shares this image with a partner, that apparently, you know, she doesn't have any right to that image now remaining private. And so for me, when I'm my own research, I kind of look at things from both the privacy rights afforded to victims, but also the privacy rights afforded to perpetrators. I think currently and formerly incarcerated people still also are very marginalized and are routinely surveilled even once they are released from their incarceration facilities, and not just them, but their families as well. And I think, you know, you bring up these really interesting points about classism and how that really needs to be in our discussion sort of moving forward. We have this discussion about racism being built into these systems, but I think really classism is a big part of this as well that doesn't necessarily get as much attention as it deserves. And you have so many underserved populations who never get to have this conversation about, should I be surveilled? I don't know. You know, those who are on government assistance don't get that option. They just have to give over their information. And so I think more than anything, I appreciate the fact that you brought in sort of this law and society perspective as well and helped kind of bring in the conversation of where does class also come into this? Because it definitely is not talked about enough, particularly for marginalized groups.
Yeah, thanks so much, Divya. And it's such an important point. I mean, I and just to underscore, you know, I think that, and this is one, I actually at one point had a whole section on, you know, criminal, or wanted to have a whole section on criminal records, ban the box type litigation, because absolutely, I think that is a population who is, you know, of course, while they're in prison, but even once they're out, they're subject to just manifold privacy infringements by the government and by private parties alike. And that too creates a cycle of subordination, right? Like we like to pretend that our justice system has something called, you know, there are gestures made towards rehabilitation, and it's like, well, it really is more maybe gestures towards that, but more strongly it's like continued subjugation. Interestingly, and in some ways, to bring things full circle, I think that we need to have that lens with regard to all kinds of perpetrators too, including, you know, some of the perpetrators involved in the NCP context, right? Like sex offenders are some of the people who, once released from prison, are the most heavily surveilled by the government, including through sex offender registries, right? And so I think it's an area where we need to, consistent with what you're gesturing to, Divya, think really holistically about who counts as marginalized. And, I think that and who is precarious. And something that I mentioned at the beginning of the book, but I think I'm constantly trying to bear in mind myself, is that privilege and precarity are not constants, and they ebb and flow over time. And someone can be extremely privileged in one context and extremely precarious in another. So, a person who commits a sex offense through NCP is privileged in that context and making someone else precarious. But to the extent that they're, incarcerated, subject to a sex offender registry on the back end, they are precarious. And how should we be designing privacy protections that bear in mind that precarity in a consistent way? And I think that if people who care about privacy are sort of consistently caring about privacy in these different contexts, even when it's uncomfortable, my view is that will lend greater credibility to our arguments, not necessarily detract from them. But I'm very interested in people's reactions to that.
Well, since we're close to the top of the hour, I'm going to leave that as a provocation that you can all think about, except to note that perhaps Nixon was an unpopular victim in that period of time as well, given that he was, not a very popular individual, and his privacy wasn't something that, whether it was the court or probably the general public, that's sympathetic.
Though there is an irony that, he got in trouble in first place dealing with a privacy violation.
Well,
precarious, but very privileged.
let me say that, I was pleased to be invited, but one of the consequences was that I had to pull out this brief, which is 178 pages. I was the brief writer at Miller, Cassidy, LaRocca, and Lewin. So my family is furious that I've never written a book. But here was 178 pages, most of which I guess I wrote. I guess I've written thousands of pages of briefs, but no book. But the interesting thing is that in that book is a very warm greeting to me from Richard Nixon, typical Nixon style for his lawyer. It says, "To Nathan Lewin, with appreciation and best wishes, Richard Nixon." So I thank Jules for making sure that I took this off my shelf and was able to remember that I had written 178 pages and gotten the thanks from Richard Nixon.
I understand Donald Trump doesn't pay his lawyers. Did Richard Nixon pay his lawyers?
Well, we were paid ultimately, years after Nixon died, when this case, the whole question, the Supreme Court said in its opinion that Nixon was entitled to be compensated for his papers. And that began litigation that took years after Nixon died. And finally, it was settled, and we got some, quite frankly, very modest payment for the services that we had rendered to what was then the estate of Richard Nixon.
On that note, let me thank Professor Scott Skinner-Thompson, for the book and for the time, and let all of you go back to busy work days and to grading finals and all those lovely things. Ping us. Marcus is going to send out, as we always do, what's on your shelf, what do you want to read next? And we've got some ideas of privacy books here that we need to be reading, or broader tech policy, the adjacent issues. Like many said, it's as much about power and the social issues nowadays as it is the tick boxes and the cookie banners. So thanks to everybody who joined us in the audience, and great to see you all.
Thanks so much.
Thanks all. Bye.